All right, welcome back to the channel, everybody. I am still on vacation and I am still sick. I am not camera ready. No, sir, no, I am not. However, I do have some things to read because the documents keep getting filed fast and furious in the What the Hales case. And in order to keep up, well, I got to keep going. So let's get to it, shall we? All right, we've got the brand new. Oh God, when I say brand new, it's not even new. I mean, it's already old and it's only been out for like what, a day and a half? Let's see if I can make this bigger. That's what she said. Okay. The United States District Court, this is an order from Judge Blytho or Bletho or however the hell we're saying it. I still don't know. Um, and this is an order denying Bruce's motion to dismiss this case. As the judge has said multiple times, it's going forward. We are going forward with this case. But let's go through the order and read what he said. This matter is before the court on defendant's motion to dismiss. And again, we are talking about Jeremy Hales versus Lynette Preston and John Cook. This matter is before the court on defendant's motion to dismiss for lack of subject matter jurisdiction under federal rules of civil procedure, blah, blah. Plaintiff has responded in opposition. Document 80. No hearing is necessary. By the way, look at what we're at. We're at document number 103, 103 in this case. It's crazy. Early in this litigation, defendants moved to dismiss for lack of subject matter jurisdiction, docs 5 and 6. The court denied that motion and found subject matter jurisdiction existed under 28 U.S.C. 1332 because there was diversity matter jurisdiction that existed under 28 U.S.C. And the amount in controversy exceeded $75,000. Defendants have now filed another motion to dismiss for lack of jurisdiction, arguing that the amount in controversy requirement is no longer met. Although defendants are correct that plaintiff can no longer receive treble damages or attorney's fees for violations of Florida's RICO Act because those claims have been dismissed, defendants are incorrect that this fact deprives the court of jurisdiction. And here comes the embarrassing part. This was settled back in 1938. Events occurring subsequent to the institution of suit which reduce the amount recoverable below the statutory limit do not oust jurisdiction. And this is from a case from 1938. Acknowledging the well-settled rule that a federal court does not lose jurisdiction even though the amount recovered falls short of the jurisdictional amount. So just like Randy said, it wasn't going to be dismissed because his claims don't hold water. A court's analysis of the amount in controversy requirement focuses on how much is in controversy at the time of the case's filing in federal court, not later, which is exactly what Randy said in his response. Thus, a post-filing development that reduces the alleged amount in controversy to below the statutory threshold does not destroy diversity jurisdiction. Boom, roasted. This rule responds to the difficulties of assessing a suit's value and the likelihood that the calculation will change over the course of litigation. Because the alleged amount in controversy does not cap damages, constant litigation over the matter having the potential to alter a court's jurisdiction would be wasteful. Therefore, even if dismissal of plaintiff's Florida RICO claims has been made recovering the needed amount possible, the dismissal is a post-filing development that does not destroy diversity jurisdiction in this case. Basically, he's telling him 4 different ways that this is, just stop trying to make fetch happen. It isn't going to happen. You're wrong. Given this rule and the court's previous determination that the amount in controversy requirement was satisfied at the suit's outset, defendant's motion to dismiss under the rule lacks merit. Oh, it's meritless, eh? Another meritless filing? Geez, what do we call that again? Is it multiplying litigation? What does he call it? Multiplication of proceedings? And what's his polyflop again? Protraction of litigation, perhaps? Weird. explaining that even if part of the plaintiff's claim is dismissed, for example, on a Federal Rule of Civil Procedure 12B or summary judgment motion, thereby reducing the plaintiff's remaining claim or claims below the requisite amount in controversy, the district court retains jurisdiction to adjudicate the balance of the claim. Spicy footnote number 1. The court is unpersuaded by the defendant's argument that this general rule should not apply because plaintiff acted in bad faith. The court does not find the plaintiff acted in bad faith in asserting at the time of filing that the amount in controversy exceeded $75,000. Whether plaintiff can ultimately recover more than $75,000 is a different question than whether the amount in controversy was met when this case was filed. Explaining that the plaintiff's likelihood of success on the merits is largely irrelevant to the court's jurisdiction because the pertinent question is what is in controversy in the case, not how much the plaintiffs are ultimately likely to recover. This is a very important footnote because Jeremy has a ruling by a federal judge that says he did not act in bad faith. So the question is, the ecosystem continually saying every night that he did act in bad faith and that he filed meritless claims. Can that be added to his defamation claims? Because a judge has said they're not. He said it's not in bad faith. It is not without merit. And it's interesting that they keep on saying these things because they aren't true. So, accordingly, defendant's motion to dismiss for lack of subject matter jurisdiction is denied. Insert denied button here, which I don't have. All right, so that was denied. Man, 104 documents already in this case. I mean, wow. And that's not even the end of it. So where are we at here? Let's catch up. We had Bruce filing a motion to strike the motion for sanctions, which got denied. Judge orders Randy and what's his name, Manskin, to come to Pensacola on April 3rd for a show cause hearing as to why Bruce's pro hoc vice status shouldn't be taken from him, yanked and yeeted. So Bruce files to try to strike that. He gets denied. He can't strike it. He's got to go. He's got to show up. And then he gets a second denial right in a row for his motion to dismiss. It's lose, lose, lose every which way this guy turns. And he wonders why we make fun of him for being a bad lawyer. But I'm sorry, this is not good lawyering. This is the opposite of good lawyering. This is what we call bad lawyering. And he's not doing his clients any favors. What he is doing is exactly the thing that he accuses Randy of doing. All right, let's go to the next documents that have dropped because the judge said in the order to show cause, stop filing stuff because we're going to have this out on April 3rd. Don't file just file your response. That's it. But Bruce still hasn't filed his response, but he has filed other things. And what are those other things? Oh, God. It's just a bunch of whining like you cannot believe. So let me open up that. I believe it is document, 104 and 105, which is right after the judge's order. Motion for attorney's fees under 28 U.S.C. 1927. Defendants move pursuant to 28 U.S.C. for an order that the plaintiff pay a reasonable attorney fee as a sanction for unreasonably and vexatious multiplying proceedings by falsely accusing the defendant's counsel of fabricating quotations from legal authority, as well as other misrepresentations in the plaintiff's opposition. Document 80 to the defendant's recent 12B1 motion. Now, this is a 5-page motion. How excited do you think the judge is going to be to read this before the sanctions hearing? Now, Randy's asking for sanctions, so Bruce has to ask for sanctions back. I mean, I can't wait for the judge's response to this. I don't know what it's going to be, but I can't imagine he's going to like it. He says, Bruce here says, document 80 was replete with misrepresentations to influence the court's view of the issues and authorities raised in the defendant's 12b1 motion. As it was necessary to respond to ensure the court was not unduly misled, the defendants requested leave to file a reply, document 83, which the court granted, document 84. The defendants thereafter filed the reply, document 87, addressing the misrepresentations contained in the plaintiff's 12b1 opposition. The plaintiff's misrepresentations thus resulted in multiplying proceedings by necessitating the request to file a reply, document 83. The court's ruling on that, doc 84, and the reply itself, doc 87. 28 U.S.C. 1927 provides, any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof, who so multiplies the proceedings in any case unreasonably and vexatiously, may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. Under the plain language of the statute, 3 factors must be present in order to justify an imposition of sanctions. An attorney must engage in unreasonable and vexatious conduct. 2, such unreasonable and vexatious conduct must multiply the proceedings. And 3, the amount of the sanction cannot exceed the cost occasioned by the objectionable conduct. Have you noticed that he hasn't used polymop? Yet he's using multiplication of proceedings, which is a real thing, but he hasn't used his acronym. Do you think we've successfully shamed him out of it because it's stupid and it's not a thing? So far, I don't see him using it again. Smith v. Psychiatric Solutions, more particularly, the term unreasonably necessarily connotes that the district court must compare the attorney's conduct against the conduct of a reasonable attorney and make a judgment about whether the conduct was acceptable according to some objective standard. The term vexatiously similarly requires an evaluation of the attorney's objective conduct. Meaning without reasonable or probable cause or excuse, harassing, annoying, which are all things that I would describe Bruce's filings as. But, you know, that's just me. Although the attorney's objective conduct is the focus of the analysis, the attorney's subjective state of mind is frequently an important piece of the calculus because a given act is more likely to fall outside the bounds of acceptable conduct and therefore be unreasonable and vexatious if it is done with a malicious purpose or intent. It is objectively unreasonable and vexatious to make false accusations, accusing counsel of fabricating quotes from legal authority. Well, Bruce, you cited it wrong, which led Randy to believe it was fabricated because it looked fabricated because you cited it incorrectly. So you didn't make up quotes like Randy thought you might have, because that's what it looked like. We discovered what you did was you just cited them all wrong. And so it made it look like these 2 other quotes were coming from different cases, but they were all quoted as one, but you separated them. I mean, you did it all wrong. And and Randy was absolutely right that the quotes you claimed were in this one lawsuit, a Supreme Court case, weren't there. They were somewhere else. And you cited it wrong. And maybe that wasn't on purpose. Maybe it was just sloppy, maybe it was lazy. I don't know. But Randy has a right to point it out to the judge that, hey, I couldn't find this. An award of attorney's fees is warranted under 28 U.S.C. 1927, regardless of the outcome of 12b1 motion, because the plaintiff multiplied proceedings by necessitating a response to the false accusations and misrepresentations. Although the court denied the defendant's 12b1 motion, the decision, document 103, did not address the false accusation contained in the plaintiff's 12b1 opposition that the defendant's counsel fabricated legal authority, which alone is grounds for imposing sanctions. Okay, Bruce, this is not going to work out well for you. So you noted that the judge did not comment on it, which means he didn't want to. It means he didn't need to. And you're saying here, hey, judge, you screwed up. You didn't comment on this thing that I want you to comment on, and so now I'm going to make you. Oh my God. This is not how you get along with judges who are in charge of your case. A judge who is about to hear a show cause hearing about why he shouldn't kick you out of Florida and reference you to the bar. This is a stupid idea. Hey, judge, you're wrong. You didn't address the false accusations. Oh my God. And then he quotes this case here, which I'm not going to read this whole thing. This is basically just about another case where they found the attorney had acted in bad faith. Unlike an email underlying the plaintiff's motion for sanctions in document 96-1, the plaintiff's false accusation was made in this case in a court filing and not a private email, and in his capacity as counsel, not a litigant whose address had just been publicly doxed along with 9 others. Oh God, he's still doing this. Nobody doxed you except your ecosystem, because we always redact addresses, so I don't even know what he's talking about. It was an attack on the integrity of the undersigned. But do you have integrity, Bruce? Because I haven't seen any. Complete with a purposeful alteration of the cited excerpt from the defendant's memo to make it look like the false accusation was true. It necessitated a response, ensuring the court was not misled on the issues before it. Well, then, Bruce, don't you think the judge would have mentioned it if it bothered him in some way? But no, you're filing, making him mention it now. I'm sure this is going to go swimmingly for you. Unlike the plaintiff's motion for sanctions, which has nothing to do with any proceedings and was filed without compliance with a local Rule 7.1 certification requirement, the judge has already ruled on this. He said he did it right. Oh my God. Bruce, stop. This is embarrassing. The plaintiff could have opposed the 12b1 motion without falsely accusing the undersigned of fabricating a quotation from legal authority, a direct attack on the integrity of the defendant's counsel, to which he was compelled to respond. The plaintiff could have refrained from falsely suggesting that the undersigned independently contacted whatnot to interfere with the plaintiff's contract, another smear in the guise of evidence necessitating response. I can't believe the way this guy writes. God, he's attacking plaintiff's counsel again, accusing him of smearing him. The plaintiff could have opposed the 12b1 motion without distorting Amanda Martin's testimony and without rehashing a prior false accusation that the defendant cited to non-existent legal authority in the prior 12b1 motion. How did he distort Amanda Martin's testimony? Is he going to explain that? Because I don't know how that is a thing. These misrepresentations necessitated a response for which leave was granted and time expended to prepare and file, and for which an order to pay attorney's fees under 28 U.S.C. 1927 is warranted. Conclusion. Unless it is acceptable for a party to falsely accuse an opposing lawyer of serious misconduct, such as fabricating authority, or unless the falsely accused lawyer's time responding to such a spurious attack on their integrity is of no value, the court should award the defendants a reasonable attorney fee to be paid by the plaintiff. Well, why is he getting... I thought he was doing this for free. If he's doing it for free, then it hasn't cost him any money. And so why does he deserve money? He didn't put any money out. Nobody has lost any money on his side. He already volunteered to spend his time doing this. Does he get to ask for attorney's fees when he's doing it allegedly pro bono? Interesting question. All right, let's go to the next one. Because, oh yeah, there's another one. I mean, I hate to inform you that there is another one, but there is, because we can't just... This is why we can't have nice things, folks. This is why... Bruce is why we can't have nice things. Because we have to continue, we have to keep up with this every day. I was thinking of splitting these into 3 separate videos, and then I realized, oh my God, if I do that, I'm sure there's going to be like 6 more documents by tomorrow. So no, I'm going to have to do them all at once. All right, here we go. All right, here is the next one. Now, he filed these within 10 minutes of each other. Here's another motion for sanctions, motion for attorney's fees under 28 U.S.C. 1927. So we're going after the plaintiff to pay reasonable attorney's fees as a sanction for unreasonably and vexatiously multiplying proceedings Notice he doesn't say polymorph. By filing frivolous motions to dismiss or strike counterclaims, Docs 85 and 86, based on the fabricated premise that the counterclaims named the plaintiff's counsel as a party defendant. You did. You just didn't add him to the actual parties, but you accused plaintiff's counsel of doing all sorts of crap. Memorandum in support, 28 U.S.C. provides any attorney or other person admitted to conduct cases in any court. All right, we've already read this. Blah, blah, blah. He has to prove here that an attorney must engage in unreasonable and vexatious conduct. Unreasonable and vexatious conduct must multiply the proceedings, and the amount of the sanction cannot exceed the cost. Why didn't he just put these into one? Why did he do two motions for sanctions under the exact same rule? Why didn't he just add his third thing in here or whatever? All right, I'm skipping all of this. We already read a lot of this. Putting aside the suspect timing and the appearance of being hastily conceived, drafted, and filed to counter the defendant's filing of a motion for leave to reply to misrepresentations contained in the plaintiff's 12b1 opposition, the plaintiff's motions were based on the made-up premise that the counterclaims seek to add plaintiff's counsel as a party defendant. Yeah, I can't figure out for the life of me why this wasn't just put in the last motion. Why would you do two separate motions for this? You should have just put this in as another paragraph. What the hell, man? You're making the judge read two separate motions for sanctions on this under the same rule? Why? There was no argument that the motions were supported by some authority holding that by mentioning the plaintiff's counsel in the counterclaims allegations, it means he is a party defendant, despite not being so designated. The motions simply and falsely stated that the counterclaims named the plaintiff's counsel as a party defendant to fabricate a pretextual justification to file the motions when they did. It was an abuse of the court and this litigation. The defendants waited 10 days to file their response, document 90, in case the court issued a no response necessary ruling. The court denied the motions the following day, document 91, stating, as defendant's response in opposition has confirmed, and the court itself had concluded based on its review of defendant's answer, no counterclaims have been asserted against plaintiff's counsel. Thus, there are no counterclaims against plaintiff's counsel to dismiss. Now, in going back over that rule in that motion, I thought the judge was wrong because he very clearly names plaintiff's counsel multiple times and is accusing plaintiff's counsel of doing something wrong. So I don't know how that doesn't add him. I don't understand. I don't know how the judge came to that conclusion, but he did. Thus, the court was waiting for the defendants to respond before ruling on the plaintiff's motion, making it unavoidable that counsel would need to expend the time to do so. It is objectively unreasonable and vexatious to fabricate false pretexts to justify filing motions to dismiss. Hey, I would have filed the same thing. I would have seen mine if I were plaintiff's counsel and I saw this guy trying to blame me for things, not my client. I would have thought, hey, judge, I'm not in this. Why am I in this? I think it was perfectly reasonable. I don't think it's unreasonable at all. He says here it's objectively unreasonable and vexatious to fabricate false pretexts to justify filing motions to dismiss. Attorney fees are warranted, blah, 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 and it's multiplying proceedings. Okay. Conclusion, because the plaintiff's motions unreasonably and vexatiously multiply proceedings, the court should award the defendants a reasonable attorney fee to be paid by the plaintiff. Again, why does he get attorney's fees? He is pro bono. He's pro bono. Why do we have attorney's fees? What fees have you incurred when you are doing it for free? If you don't have a contract with your client promising to pay you a certain amount and you're not billing her by the hour, then what the hell are you talking about? Anyway, I guess his time or whatever, but what is his time worth when he's put $0 worth on his time? He says he's doing it for free, which of course no one really believes. Do we? Do we really believe that he's doing anything for free? I don't. All right. So I have heard that there may actually be another filing, but I haven't seen it yet. And if I do come across it, obviously I will give you an update. But that's where we're at right now in this What the Hales case. Jeremy Hales versus Lynette Preston and John Cook has gone wildly off the rails, and it's a lot of fun to watch. Not so fun if you are a litigant in this case, but it is entertaining for the rest of us because this is something that we've just never seen before. I've never seen such a case that got papered the way this one does. Normally there's these long periods of time where nothing happens in the case while it's being decided or, while it's going through the process of getting to trial. This is just not one of those. We just have new filings every day, like boom, boom, boom. It never stops. Hopefully you're all caught up now, and I'll see you again real soon. Take care.